final addresses as prescribed by the provisions of Order 45 of the Rules of this Court. In the final address deemed filed on the 24th of January 2023, learned counsel for the defendant, Fatima Abubakar Esquire, raised two issues as having a reason for determination in the suit, namely, one, whether this honorable court has jurisdiction to hear and entertain the suit, and two, whether the termination of the appointment of the claimant was unlawful, malicious, null and void, and of no effect. The claimant in turn filed this final address, also deemed properly filed on the 24th of January 2023, wherein Levi I. Shapira, Esquire of Learned Counsel, distilled three issues as having a reason for determination in this suit, namely, one, whether or not the claimant's action is statute barred and has consequently robbed this honorable court of its jurisdiction to hear and determine the suit on its merits. Two, whether or not the claimant's appointment can be lawfully terminated for the alleged reasons of record of insubordination and unproven offense of perjury. Three, whether or not the claimant has proved his case to be entitled to the reliefs claimed by the claimed against the defendant. Upon a proper appreciation of the totality of the pleadings of the respective parties, the evidence adduced at the trial, and the totality of the circumstances of this case, it is my considered view that the suit must be decided on a lone issue without prejudice to the issues severally formulated by learned counsel to the respective parties, as, I quote, whether or not the claimant established his entitlements to the reliefs claimed in the suit against the defendant, end of quote. I should state the position of law. I should restate the position of law that in an action for declaratory relief, such as the present case, the claimant is duty bound to previous claim on the strength of his own case. This is essentially so because declaratory reliefs are not granted on a platter of gold. They are only granted as products of a credible and cogent evidence preferred at the instance of the claimant. See the cases of Colonel Nicholas Anyaru retired versus Mandela Limited and Nweke versus Okori, citation supplied. As disclosed in the statement of facts, the claimant was employed by the defendant as an assistant lecturer on the 31st of October 2012. The confirmation of his appointment took effect from the 13th of November 2014, and his promotion as lecturer 2 was effective from 1st of October 2015. Letter of provisional appointment, letter of confirmation of appointment, and notification of promotion were respectively tendered in evidence as Exhibit C1, Exhibit C1A, and Exhibit C2. According to the claimant, the ordeal that resulted in the termination of his appointment started sometime in April 2018. This was after he wrote Exhibit C3, a letter dated the 17th of April 2018 to the acting Vice Chancellor to complain that one of the defendant's security officers surreptitiously gained entrance to his office, that on the following day, he was served with Exhibit C4, an internal memo where he was vaguely addressed as member, inviting him to a meeting, that he wrote Exhibit C4A to the defendant for clarification on his capacity for the invitation, that rather than reply his letter, the defendant abandoned the earlier allegation of sexual activity and issued Exhibit C5, a query on allegation of his refusal to interact with the prima facie committee, but that in spite of his reply, that is Exhibit C5A, the defendant constituted a new committee to investigate him. The claimant further testified that after several appearances, the committee recommended delay in his promotion to lecturer 1 for 2 years, that the governing council approved the recommendation in Exhibit C6, and that after the same was communicated to him, he promptly appealed the decision of the council, that is Exhibit C6A. The claimant alleged that he had been due for promotion 2 years before the decision, and he was not promoted 3 years after the decision. The claimant also testified that his consolidated monthly salary in June 2021 was 187,850 naira 25 kobo. In his further testimony, the claimant narrated the circumstances that led to the termination of his appointment. According to him, one Vandy Peter collected 1,350 answered scripts, but only 1,228 scripts were returned. That a committee was set up to find a means to recover the 52 missing examination scripts. That when the claimant was invited to appear and interact with the committee, he informed the committee that he was not involved in the sorting and marking of POL 111 course, that he was invited to appear before a second committee and before the senior staff disciplinary committee, and that he maintained the same explanation before the committees. The claimant testified further that while awaiting the report of SSDC, the said Vandy Peter found the scripts in his office and reported his discovery to the head of department, Political Science Department. The HOD constituted a committee on the discovery of the missing scripts. That his name, that is the claimant, was never mentioned in the report of the said committee on the discovery of missing scripts, but despite the discovery of the scripts, the findings of the committee on the discovery of those missing scripts, the governing council at its 21st regular meeting approved the previous recommendation for termination of his appointment, and that he was served 2 separate letters of termination of appointment, both dated the 24th of June 2021. The said letters of termination of appointment was tendered in evidence as Exhibit C10 and C10A. Letter of the examination officer, 1 Obadaun Oluwatoyin S., dated the 27th of August 2019 and captioned, quote, examination script number discrepancy, that is Exhibit C7, minutes of the 55th Departmental Regular Board meeting held on the 6th of May 2021, that is Exhibit C8, and report of the Committee on the Discovery of Missing Scripts, that is POL 111, Exhibit C9, were also tendered in evidence in support of the claimant's case. It is the further testimony of the claimant that his letter of appeal for delay in promotion had been pending before the governing council since March 2021, and that on 2nd July 2021, he made another appeal against his unlawful termination of his appointment to the governing council. The claimant testified that at its 22nd regular meeting held on the 13th of January 2022, the governing council failed or willfully neglected to consider his appeal. Basically, the defense put forward by the defendant is that the claimant's appointment was terminated having been found guilty of negligence of duty of giving examination scripts to graduate assistants against the defendant's policy and regulation. DW1 testified that an investigative committee was set up following a complaint that 52 examination booklets of students for course POL 111 were missing. That in the course of the investigation, the claimant and all the persons directly involved in the allegation were invited by the committee. That in its finding, the claimant and 2 other co-lecturers were found culpable by the committee, and the dean of the faculty constituted 2 other committees to further investigate the allegations. DW1 testified further that the committees made recommendation to the senior staff disciplinary committee for further investigation of the claimant, that at the end of the SSD investigation, the claimant and the other 2 lecturers were found culpable, and a recommendation was made to the governing council for the termination of the claimant's appointment. The defendant maintained that due process of law and rules of fair hearing were followed and observed in terminating the claimant's appointment. The defendant further contends that the claimant is not entitled to the reliefs being sought. The report of the Faculty of Social Sciences Committee on Missing POL 111 Examination Scripts, that is Exhibit D1, report of Investigative Committee of the Missing 52 Answered Examination Booklets, that is Exhibit D2, the fourth report of Senior Staff Disciplinary Committee, that is Exhibit D3, and the report of the Senate's Prima Facie Committee that investigated the loss of 52 answered examination scripts, that is Exhibit D4, were tendered by the defendant to buttress its case. I note that an issue of jurisdiction of the court and the competency of the suit was raised by learned counsel for the defendant in the written address. The issue is predicated on the ground that by virtue of Section 2A of the Public Officers Protection Act, POPA 2004, the claimant's case is statute barred. Learned counsel argued that the defendant falls within the categories of persons protected by the provision of Section 2A of the Act. Learned counsel further argued that the institution of the instant suit against the defendant on the 8th of February 2022 is beyond the statutory 3 months permitted by the Act, and urged the court to hold that the claimant's action is statute barred as the period prescribed to institute the action had elapsed. In reaction, learned claimant's counsel argued that the present action is predicated on contracts of service and submitted that the provision of Section 2A of the POPO is inapplicable to contracts of service. The case of National Revenue, Mobilization, Allocation, and Fiscal Commission, and 2 others versus Ajibola Johnson and 10 others, 2019, 2 Nigeria Weekly Law Report, Part 1656, page 247 was inter alia cited in support of a submission. Now, the principles that guide the court in determining whether an action is statute barred are well settled and well too known. These principles have also been adequately captured and canvassed by respective learned counsel in their written addresses. Without having to recapitulate the said principles, it suffices to restate that the overriding factor or consideration is that the essence of a limitation law is that the legal right to enforce an action is not a perpetual right, but a right generally limited by statute. It is equally settled that a cause of action arises on the date or from the time when a breach of any duty or an act occurs, which warrants the person who is injured or the victim who is adversely affected by such breach to take a court action to protect his right that has been breached or violated. See the cases of Odubeko versus Fowler, Eboigbe versus NNPC, Ekeoku versus Aliri. Citation supplied. As correctly submitted by learned claimant's counsel, it is settled that in order to determine whether or not a court can exercise jurisdiction over a matter, it is the facts averred in the complaints and statement of facts and the reliefs endorsed therein alone that the court is required to examine and no more. See the cases of Muyosore versus Governor of Kwara State, Guinness Nigeria PLC versus SKN Nigeria Limited, citations supplied. As gleaned from paragraphs 25, 26, 27, and 28 of the statement of facts, the claimant's grievance against the defendant is that his appointment was terminated despite his pending appeal before the council, that after the termination of his appointment, he lodged the second appeal on the 2nd of July 2021, but at its 22nd regular meeting held on the 13th of January 2022, the council failed or willfully neglected to consider a second appeal. Being therefore aggrieved by the action of the defendants, the suit was instituted on the 8th of February 2022. From the above facts, it is deducible that the cause of action arose on the 13th of January 2022, that is, after the Governing Council refused the claimant's appeal, and I so hold. Without further ado, the defense that the claim is statute barred is not available to the defendant, and I so further hold.
As a court, please.
The task the court is to undertake is to examine the evidence on record as adduced by the claimant in order to determine whether or not the evidence has satisfied the requirements of proof imposed by the provisions of Section 131 and 132 of the Evidence Act 2011 as amended to substantiate the claimant's claims as endorsed in paragraph 35 of the Statement of Facts against the defendant. In his testimony, the claimant narrated the circumstances that resulted in the termination of his appointment. The story as told by him is that he got an invitation through a memo of 18th of April 2018 to appear before an investigative panel, that he also wrote to seek clarification on the capacity he was invited, and this request was also made when he appeared before the panel, but that the defendant did not respond to his request. The claimant further testified further that he got a query for refusal to interact with prima facie committee, that despite his response to the query, his promotion to the rank of lecturer 1 was delayed for 2 years by the recommendation of the committee, and that he made an appeal to the Governing Council that has been pending since the 4th of March 2019. The further testimony of the claimant is that he was invited to appear and interact with the Departmental Committee on Investigation of Lost Answered Scripts, and that when he appeared before the committee, he stated his role during the examination of course POL 111 and also presented his defense, that he was again invited by SSDC for interaction, that while awaiting the report of SSDC, the lost, missing answer scripts were found, which prompted the HOD to constitute a committee on the discovery of the missing scripts, that the committee presented the report on the discovery of the missing scripts, but despite the discovery of the scripts and the report of the committee, the Governing Council, at its 21st regular meeting, approved the termination of his appointment. Now, the general principles guiding the proof of a claim for wrongful, unlawful termination of dismissal of employment have remained sacrosanct. It is a universal evidential principle that the burden of proof in any case is on the person who desires a court to give judgment as to any legal right or liability dependent on the existence of facts which that person asserts, or who will fail if no evidence were given on either side. In labor law, it is equally settled that the onus is squarely on a claimant in an action for unlawful dismissal or termination of appointment to prove the existence of the contracts of employment, the terms and conditions thereof, and how those terms and or conditions were breached by the employer. Following the above principles, the claimant hearing, please, whoever is talking that we're hearing online should mute the device, please. Following the above principles, the claimant's hearing must not only plead and prove the terms and conditions of his appointment, he must also prove that there was a departure from the prescribed procedure, or that in applying the procedure, there was violation to the rule of natural justice so as to render the former compliance a travesty. See the cases of Nwachukwu versus Nguze, Waek and others versus Nkeng, Nigeria Gas Company Limited versus Judicial, Oloruntoba Oju versus Abdurrahim, and Emma Swain versus University of Benin, citation also applied. Now, from the totality of the evidence adduced by the claimant, could it be said that he has satisfactorily established that his appointment was unlawfully terminated by the defendant, alleged to entitle him to the reliefs he claimed? I had painstakingly searched the whole gamut of the claimant's statement of facts and reply to the defendant's amended statement of defense, I am unable to discover from close reading any reference to the conditions of service regulating the employment. Neither was there any pleading by the claimant on the manner the defendant departed the prescribed procedure in terminating his employment. As a matter of fact, the testimony of the claimant is that he received several queries and was invited by several committees for opportunities to present his defense on different allegations that were leveled against him. In a bid to redeem this blunder, Learned Claimants Counsel, relying on the provision of Section 122 of the Evidence Act 2011, urged the court to take judicial notice of the Federal University Dutsima Katsina State regulation governing the conditions of service and scheme of service of senior staff, revised August 2017. The simple question to be answered here is whether the regulation governing the terms and condition of service of senior staff of Federal University Dutsima regulations / condition of service are such that the court can take judicial notice. Section 122 of the Evidence Act supra empowers courts to take judicial notice of certain facts. Subsection 2, relevant to this discourse, provides, I quote, the court shall take judicial notice of the following facts. A, all laws and enactments and any subsidiary legislation made under them having the force of law now or previously in force or hereafter to be in force in any part of Nigeria. B, all public acts and all laws passed or hereafter to be passed by National Assembly or State House of Assembly, as the case may be, and all subsidiary legislation made under them, and all local and personal acts or laws directed by National Assembly or a State House of Assembly to be judicially noticed, end of quote. The above provision is clear on facts the courts are enjoined to take judicial notice. It includes all laws or enactments and subsidiary legislation that is made. While a court can take judicial notice of any law, the same cannot be said of a staff regulation, which can best be ranked as a public document. Its authenticity, or otherwise can only be properly considered by the courts after it has been duly admitted in evidence. In Abacha versus Fawahimi, 2004 Supreme Court of Nigeria judgment at 400 at page 458, the court per NY for JSC said, I quote, when a document is produced before a court for the purpose that it is used in the proceedings, the proper procedure is to tender it formally. If it is admissible, it is accordingly admitted as exhibit in its original form. But if it is document that cannot be parted with by the person in whose custody it is, or the original is not available, a copy or certified copy as secondary evidence in appropriate cases will meet the occasion. I do not think it was a question of recourse to taking judicial notice, as the learned judge said, end of quote. Similarly, at page 458, the court again held, I quote, when a court takes judicial notice of a legislation under section 75(1) of the Evidence Act, that is the 122 of the present act, the legislation is placed before it, and it takes judicial notice of its contents and the facts that the legislation was duly made, end of quote. It is equally trite and elementary to restate that address of counsel is not evidence, and that which cannot be relied upon by a court for purpose of proof and a claim before it. In other words, no address of counsel can serve as substitute for evidence. It cannot be overemphasized that in cases of unlawful termination or dismissal of employment, the conditions of service must be pleaded and proved, being the bedrock of a contract. It is not the duty of the employer as defendant to prove that termination was unlawful. C. Okwebo versus Police Council, and the case of Idoniboye Obu versus NNPC, citation supplied. The claimant did not plead or tender the conditions of his employment with the defendant and did not prove the manner the defendant breached the condition of service. This is the bedrock of his case. Having not pleaded or proved that there was a departure from the prescribed procedure by the defendant, he erected his case on a quicksand and must fail. I shall further state the facts alluded in paragraphs 4, 5, and 8 of the reply to the amended statement of defense that the major aim of the committee was to maliciously recommend the claimant for termination, that the departmental committee that investigated the claimant was set up by one Dr. Isaac Akuva in his official capacity as HOD, and that the report of the Faculty of Social Science that exonerated the claimant was outrightly rejected, and another committee was surreptitiously constituted to find the claimant culpable were not proved. It is strict law. The onus of proving a particular fact lies on the party asserting. Thus, in civil cases, the onus of adducing evidence is upon a party who will fail if no evidence is adduced. On the issue of perjury before the committee, it is the further argument of Learned Claimants Council that the defendant cannot lawfully terminate the claimant's appointment on the frivolous and unproven reason that the claimant committed the offense of perjury before the committee. It is trite that in determining the issue of unlawful termination of the appointment, court must confine itself to the letter of termination of appointment and not go outside it to look for other reasons which the claimant thinks are behind the termination. See the cases of CBN versus Amila, Nwoha versus Mobile Producing Nigeria Limited, Awalu versus Managing Director, Unity Bank, citation all supplied. The reason for the termination of appointment of the claimant as stated in paragraph 2 of the letter of termination of appointment, that is Exhibit C10A, is for, I quote, being found guilty of knowingly against policy and regulations, gave scripts to graduate assistants without documenting or counting them first on the insistence of the HOD, Dr. Isaac I. Akuva, which clearly shows negligence of duty that led to the lost 52 answered examination scripts, end of quote. Having stated clearly the reason for the termination of his appointment, the court is confined to the reason stated therein, and I so hold. At this juncture, it is considered pertinent to restate the time-honored cardinal principle of the judicial process that relief sought by claimant in an action is fundamental to the fate of that action. Indeed, the relief sought is the bedrock and life wire of an action. Therefore, where the relief sought is uncertain, uncategorical, or is not supported by evidence or record or does not reflect the course of action, the entire exercise in proceedings becomes futile, as there will be nothing for the court to grant at the end of the day. The court will be compelled to throw out the action. See the cases of Joe Galde Co. Limited versus CDB PLC, the case of Usoku versus Ezonu, the case of NECA BBB Manufacturing Company Limited versus ACB Limited. Keeping this principle of law in focus and having not pleaded and proved the condition of service regulating the employment, the claimant's claims fail in its entirety. On the basis of the foregoing analysis, therefore, I must, and I hereby resolve the sole issue for determination in this suit against the claimant. It is therefore the conclusion of the court that the claimant's claim lacked in merit and substance. The suit shall be and is hereby accordingly dismissed. Past parties shall bear their respective costs.
Pastor Caesar.
As a copy.
Thank you very much, my Lord. We thank you for.
Thank you. The judgments will be transmitted by the end of this week. You can apply from next week by God's grace. Thank you.
Thank you very much, my lord. May you be elevated to the higher rank, my lord. Thank you very much.
Amen. Thank you. Can you call the next case, please?
Case number 1, NICS/KD/08/2020 between Adeniyi and Governing Council, Kaduna Polytechnic, and another.
Yes.
Parties absent, my lord.
Appearances?
No, the plaintiff is here with me.
Okay.
Yes,
Claimants?
the claimant, sorry, my lord. Yes, the claimant is here with me.
Claimants present.
Very well, my lord. May it please, Honorable Court, Shehu Bashir.
Defendants absent.
Defendant absent.
Yes, appearances, please.
May it please, this Honorable Court, Shehu Bashir. My humble appearance is for the claimant.
Yes.
With the greatest humility and respect, my name is A. Ishaq, appearing for the defendants, my lord.
Yes.
My lord, the matter is for adoption of final written addresses. We are ready, subject to the convenience of the Honorable Court.
Yes.
My lord, we have a pending application. The application is dated the 22nd day of February and filed on the 27th day of February 2024.
Seeking for extension of time within which to file your address.
Very well, my lord, out of time.
Mr. Ashak, you've been served, and what is your
Yes, my
reaction?
lord, we have no objection.
Although in circumstance, may I humbly move in terms of the application and urge my lord to grant him approval. Most of that, sir.
Application granted. Time is hereby enlarged within which the claimant may file the written address.
I have a copy.
They already filed and served. Address is deemed as properly filed and served.
As a copy.
Yes.
My lord, the defendant's final written address was filed on the 17th day of October 2023.
Yes.
And in response to the claimant's final written address, the defendant filed a reply address. Forgive me, my lord, I couldn't trace my copy, but we have filed a reply address. I'm so sorry.
Okay. It was filed on the 12th of March 2024.
Thank you, my lord. My lord, we humbly adopt the defendant's final and reply addresses as our arguments and urge my lord to dismiss the claim. We are most obliged, my lord.
Yes, claimant counsel.
Yes, my lord, in response to the defendant's final written address, the claimant, he qualified his final written address dated the 22nd day of February 2024.
On what date it was deemed filed today? What day was it filed? 27th February 2024, deemed filed today. Yes? You're on mute or you are hanging, whichever one. Mr. Bashir, we can't hear you again. I will deem your address as adopted.
As accomplices.
We adopt the said address and urge the courts to grant the claimant's claims.
As accomplices.
Court cases adjourned to the 1st of July 2024 for judgment.
As accomplices. We are most
So you
obliged,
can
Milord.
please communicate the date to Mr. Bashir. It seems that his network failed at a point, so kindly communicate the date to him, the registry, and Mr. Ishak.
Yes,
Mr.
ma'am.
Ishak, you are now a professor now, a doctor. We should stop calling you a mister. Is he a doctor or a prof?
I'm an associate.
Very well. Thank you, sir. So the cases have been adjourned to the 1st of July 2024 for judgment.
Thank you, Milord. Grateful.
The court will rise, please.